please come up, and we're going to look into an incredibly important topic. Sarah and Sophie, give the guys a round of applause. Those two should be on.
Thank you, JJ, and hi everyone. And a massive thank you as well to my co-presenter today, Sophie Dawson, who is a partner at Bird & Bird and a privacy law expert, and who has taken time out from a number of pieces of litigation to be with us today. So thank you, Sophie. So today we are going to be talking about looking ahead to the next round of privacy reforms and future-proofing compliance strategies. Excellent, the clicker works. So we have a packed 20 minutes. First, I'll hand over to Sophie to talk about the current state of play, so laws that are in place now and enforcement standards and trends and what's happening in the real world. And then I'll talk about what lies ahead in terms of privacy law reform. And finally, I will hand back to Sophie to talk about how organisations can plan for change and future-proof their compliance strategies. So over to you, Sophie. There you go.
Thank you. Thank you very much, Sarah, and thank you for inviting me to speak today. What an exciting time for people to be doing the jobs that you're all doing. You're in the eye of multiple changes, of which obviously privacy laws are only one. There's the change in the law, there's the change in the regulator's approach, there's the change in technology, there's the change in consumer expectations, and all of those things are obviously happening all at once. So it's a pleasure to be talking to you about just one aspect of that change today. Have we got the clicker? The clicker. So I'm going to talk to you quickly about the current state of play, just for 5 minutes, and then hand over to Sarah, who's going to talk to you about what lies ahead before we get to the practical compliance strategies. As all of you know at the moment, we've got 13 Australian privacy principles, we've got the Spam Act, and Section 18 of the Australian Consumer Law has also become a lot more important. So for those who are not familiar with it, essentially Section 18 prohibits misleading or deceptive conduct in trade or commerce. And what's happened is, instead of just having two regulators to deal with in the marketing space, being the Privacy Commissioner and the ACMA, now the ACCC, the competition regulator, has become very active as well. So what we're seeing is a lot more compliance activity than used to be the case 10 years ago, so an enforcement activity. So you can see that through the Privacy Commissioner's cases against Facebook and against Clearview. So in the full federal court recently found that the Privacy Commissioner could serve proceedings on Facebook's foreign entity because it was it had established a prima facie case that Facebook was carrying on business in Australia. In Clearview, the Commissioner found that a business that essentially was using AI to process images of people's faces collected across the world, including Australia, was breaching their APPs because it was collecting information in Australia, including photos, which was sensitive information without people's consent. So some of the change has already happened. The bar has risen in terms of regulator expectations, the amount of enforcement, as well as those other changes we've been hearing about in terms of the technology, in terms of the practices of Apple and others, and also in terms of consumer expectations. Part of the change is obviously this change from cookies to first-party data. That changes the privacy scenario as well under the existing laws, because under the existing laws, third-party cookies left open some arguments about what is and isn't personal information that aren't as readily available in a first-party data scenario. But we'll talk about a little bit of that at the end of this talk. First, I'm going to hand over to Sarah, who's going to tell you a little bit about what lies ahead. Over to you, Sarah.
Thanks, Sophie. And that's really interesting to hear about. There's law reform and then there's sort of changes that are already happening by the enforcement agencies as well. So that's important to bear in mind. So we've, I'll just, sorry, just trying to click through. Perfect. So we've heard a lot about imminent privacy law reforms, and people have mentioned it today as well. So in this part, I will talk through the regulatory context in Australia and overseas and how that will impact the law reform process, what to expect in terms of timing and changes from here, and also some key issues being considered in the process that could impact on digital advertising. So in terms of the regulatory context in Australia, you might be wondering what's likely to happen to the law reform process given we've just had a change in government. So while privacy isn't an immediate priority for the new government compared to things like energy and cost of living and the budget, privacy law reform is unfortunately unlikely to slow down. And in fact could be an increased area of focus for the government. So the significant work done by the Attorney General's Department is expected to be delivered to the new Attorney General, to Mark Dreyfus, soon, and it'll probably happen on the same timetable as what the previous government was doing. So he should receive that report from the department around about now. The Attorney General has been an advocate of strong privacy laws in the past, and so things like he's been an advocate for a privacy cause of action and other things like that. So the job of industry certainly won't be any easier under this government. So privacy law won't be going away anytime soon in terms of reforms that are expected. And once the immediate priorities are done, we can expect it to sort of speed up from there. Where we could see a change in approach is the Online Privacy Code. So some of you will remember that prior to the election, the former government was pretty keen to legislate to allow for the Online Privacy Code for social media, data brokers and large online platforms. And large online platforms was then defined as any company with over 2.5 million users annually. And it was also keen to include increased penalties for privacy law breaches across the digital economy as a matter of urgency. And so they wanted to do that before the changes around the full Privacy Act review would be introduced. So that's probably less likely to happen now, particularly the Online Privacy Code, given that Labor were really critical in opposition of pushing that through without proper consultation on the issues. So that's a bit of good news there. Another important factor that will influence our privacy law reform process will of course be what's happening internationally. Mostly, of course, these developments have seen the tide turning in favour of increased privacy protection. So, for example, in California, there's been criticism over their Privacy Act, which has led to the development of a new Privacy Rights Act due to come into effect next year, which will introduce things like expanded rights for consumer access to data and the ability to delete personal data, a right of access to information about automated decision making, and a right of data portability, so to ensure that consumers can transfer their data to other businesses, which is something that for our industry this government will be looking at as well. And there have also been proposals you might have heard in the US around a proposed ban on behavioural advertising, so an outright ban altogether, as well as an overarching federal privacy law. So these, I think, are probably less likely to come into effect anytime soon in the US, if at all. The laws have been drafted, but there's a lot of roadblocks to those actually being implemented in legislation. So that's the US. In the EU, the GDPR is also evolving, and the example I really wanted to highlight in particular is the UK. which seems to be going against the tide in a way and looking for an approach to privacy that's more business and innovation friendly, and in particular post-Brexit. So currently in the UK, the law there effectively reflects the GDPR, but the UK government has indicated that they support changes to allow low-risk processing activities that are in line with individuals' expectations. So things like network security, product safety and measurement and analytics. And the idea is that this would give organisations greater confidence that certain legitimate data processing purposes are within the scope of the law. And while these changes haven't been implemented, legislation is expected to be introduced soon in the UK to actually give effect to that. So that's kind of the context in summary, and all of these changes and developments will be taken into account by our government when they eventually put forward a final set of proposals to be introduced in Australia as well. In terms of timing of privacy reform, so I really wanted to sort of point out that even if we end up with a fast-moving law reform process, don't expect changes to be implemented within a year. So it's more likely to kind of take between a year and 2 years, or, that's probably a safe bet. So as I mentioned earlier, AGD are in the process of finalising their review and providing the report to the Attorney-General. The government will then need to respond to the report and any recommendations and indicate whether they agree or disagree. There'll then be a process of developing and consulting on draft legislation before it then is expected to pass the Parliament. So quite a few steps to go, and at least 12 months from here. In terms of what to expect from the final outcome, there's been a lot of talk about implementing GDPR in Australia, and I just wanted to point out that's a bit of a myth, or at least a generalisation. So the reform process here is likely to build on what's in place under our current Privacy Act, and so far that's what's been put forward by government is more of a combined approach in the discussion paper. So certainly some aspects of GDPR are being considered, but so are reforms from other jurisdictions. So while we still don't know what the final changes will be, I think it's fairly safe to say it won't be as simple as transplanting the GDPR into Australian law. Having said that, I might just... So having said that, the general direction of the review seems to be for higher and more prescriptive obligations in terms of how the law applies to online and in specific contexts. So the general idea is a shift in responsibility to organisations rather than expecting consumers to understand, read and consent to detailed privacy policies. Greater consumer choice and control, for example, through easy access. Sorry, just lost my little... Yeah, greater consumer choice and control, so access to privacy default settings and that sort of thing. And also new obligations for children. So there currently aren't any specific obligations for children under our existing Privacy Act. So consideration's been given to whether there should be specific obligations for both children and young people, children, young people and vulnerable consumers as well, to sort of give them a bit more protection. And it's sort of worth noting the GDPR and the California legislation have protections for children as well. So, and finally, increased penalties. So to bring the privacy law remedies basically in line with existing consumer and competition remedies, we can definitely expect to see those. But the question really is of the timing on those. Will the government rush those through a bit sooner than other Privacy Act reforms, or can we see those sort of rolled into the broader process? So in terms of some of the key reforms being considered that would impact the industry, the review's discussion paper really is jam-packed, but I just wanted to mention a few in the limited time that we have that IAB has focused on as an industry body. So first of all, we've heard a bit about it today, the changes to the definition of personal information. There have been a number of drafting changes that have been proposed that the review has put forward, essentially to make it clearer that digital identifiers and inferred information can be personal information. But of course, that's already the case under the current law when it's linked with or stored with other personal information that actually or reasonably identifies a person. So what seems to be the bigger issue in practice is determining at what point data becomes personal information in particular circumstances and what point a person becomes reasonably identifiable. But as a number of privacy law experts have indicated, there are real concerns around, that the proposed changes that are put forward wouldn't actually make it any clearer at what point someone is reasonably identifiable, but would rather just increase the scope of data that is captured under the privacy law. So obligations would attach to a wider range of data than what it does now if these changes go through. So that's one to watch. The second proposal that could have a significant impact on industry that I wanted to talk about is this new overarching obligation that all collections, uses and disclosures of personal information have to be both fair and reasonable. So this would, in a way, it would successfully shift the burden of privacy compliance more towards organisations, and it would also potentially address the issue of consent fatigue. But at the same time, the problem we have with it is it isn't completely clear what exactly would be captured as unfair or unreasonable if that type of obligation was introduced. And so, as currently proposed, there's no real guarantees for industry around uses that have become integral to the functioning of the digital economy. So things like analytics and measurement and audience segmentation, are they fair and reasonable, or at what point are they fair and reasonable, or in what context are they fair and reasonable? There's no real guarantees around that. Thirdly, I just wanted to mention, and we've heard a bit about trusted partnerships today. There will be new requirements on third-party collections. So marketers would either have to collect information directly from an individual unless it's unreasonable or impractical, and if information isn't collected directly, the organisation would need to take reasonable steps to make sure that the personal information has actually been collected fairly and lawfully, and that any relevant consents have been obtained. So that will be a sort of an increased obligation, but it sounds like a lot of you are thinking about that already, so that's great. And the final ones I just really quickly wanted to mention, there are lots. The proposal in relation to privacy defaults. So two options were put forward. The first one seems reasonable and would introduce a requirement that privacy settings should be easily accessible. The other option being considered would be more problematic, and it essentially requires that you have to have the most restrictive privacy settings set it as a default, which I think probably a lot of you know, there's been research around that suggests that would have a really serious impact on advertising, and it's also likely to be inconsistent with consumer expectations in a lot of circumstances. So we are arguing against that one on your behalf. And the last one I thought I'd quickly mention as well is the right to object, which would allow an individual to withdraw their consent to use their personal information at any time, and require the organisation to take reasonable steps to stop collecting, using or disclosing the information, and to inform the individual of the consequences of the objection as well. So the industry, in terms of the industry position, just briefly, IAB did a fairly detailed submission to the review process, and you can find that on our website. Really, the key issue is around balancing privacy on the one hand and maintaining a functioning digital economy on the other. That's something that we will have to sort of argue for and work with government for, to just make sure that that balance is achieved. It's not going to be easy under this government necessarily, but that's something that is actually really important. And I do think if you look at other jurisdictions around the world, that's really something that people are becoming more and more aware of. Also, we'll just need to bear in mind that, you know, Australia we don't want to leave Australia in a position where our laws are interpreted in a way that is much more restrictive than other jurisdictions. So if you take the discussion paper as a whole and you just implemented everything that was in it, we would have a really, really restrictive position here, and that may well be more restrictive than the GDPR when you look at it in context. So we just want to make sure as well that we get the right set of laws for the Australian context and for our jurisdiction. So just very quickly, some key takeaways. To wrap up, don't stress yet. Law reform process is unlikely to be finalised in the next 12 months. While we don't know what the reforms will be at this stage, the direction is definitely towards higher standards and greater organisational responsibility. We are working closely with government to make sure the reforms are practically workable. And in the meantime, we will keep you updated via our newsletter and website. So get in touch anytime if we can be of help. Over to you, Sophie. Thank you.
Thank you, Sarah. So now we're going to talk a little bit about future-proofing compliance. Just to add to what Sarah said, another sort of sixth element of this change is that there'll be an increase in powers for people to take direct actions potentially. And one of the things our colleagues have seen around the world is that there's been an increase in claims made by individuals. So that'll be another thing that potentially will increase the risks it already has overseas. So we're in an environment in which a lot of organisations made assessments of risk and made decisions about what risks to take some years ago. And we're now in an environment where people need to regularly revisit those risks because the extent of risk involved in particular decisions is changing because of these multiple factors, and particularly because of privacy law reform being in the offing. Obviously, one of the things everybody's thinking about is future-proofing data. We heard from one of the other speakers this morning about the fact that if you can't use data, then it's not really very useful to you. So having the right notices, having the right consents now may affect what you can do with data in the future. So whilst the changes haven't happened yet, and we expect when they do come in that there'll be a good transition period reflecting the fact that people may actually have to change not just their practices but also their software to implement the changes necessary to shape to this new privacy regime. It is important to start thinking about it now. So key things to be doing and to be thinking about are mapping and understanding relevant practices and possibilities, obviously supporting the IAB's law reform efforts, trying to be as ready as you can for the likely changes, and regularly reviewing notices, terms and conditions and consents. Because we've heard, for example, about systems that will share data across organisations. The bar is lifting in terms of the extent to which notification is expected of those practices and consents expected. Some people may be aware one of the ACCC's recent actions in the last couple of years was against an organisation which it found did not sufficiently clearly disclose its third-party data sharing arrangements and didn't get a clear enough consent. Likewise, some of the ACMA actions we've seen involve them saying your opt-outs aren't easy enough to use. So that bar's lifting, and you just need to understand exactly what it is that you're doing and be thinking in that revised risk matrix when making those decisions. One of the things to focus on, a good example, we were talking about log-on strategies, like getting people to log on and increasing first-party data, which is happening a lot. One of the things, some of the work that we've done has highlighted that there's a growing OAIC expectation, and that's reflected in the guidelines that consent be specific, voluntary and current. And so you need to think about when you're getting these consents, do your users have real choice? Are you making those choices clear, not only to them, but so that if you're later having a conversation with the Privacy Commissioner, it's clear to the Privacy Commissioner. And you need to think, well, are you going to have a consent refresh strategy? What's your time frame around that? Most people have had one of them for some time, but again, it's time to revisit it, because the proposal, one of the proposals in the possible law reforms is to change this from OAIC guidance into being hardwired into the legislation. And you need to think about bundling and also think very carefully about those information flows, what people might not expect, and whether you're telling them about those things. So you need to think like a consumer and the ACCC with your notices, because you're not now just dealing with APP5 and satisfying the Privacy Commissioner. You've also got the ACCC. Another example of a recent ACCC decision or action was, of course, that Google location data matter, and it shows just how vigilant the regulators are now in looking at what you're saying, what you're disclosing, and whether it's going to make sense to consumers. Contracts, again, people just need to keep an eye on those, because your existing precedents may need a refresh. We've, of course, got critical infrastructure legislation as well as these changes that we're talking about today. But you need to be looking at who's wearing the risk that you don't have consents or adequate notices, and think carefully again about those information flows and how big those risks are now. And so you need to be really taking that practical approach and making sure that, that you understand the extent to which you're future-proofing your practices, and that you're planning not just for your current mapping and practices, but also what you think your future mapping might look like. So that as best you can, you're telling people about those data flows, you're getting consents, and you're making that data as valuable as possible for your organisation. Now, I think we're out of time. So thank you, everyone. It's been great to see you today.
Generally excellent content there. We could have an entire day on this topic. And honestly, the amount of work that Sarah goes through in all of this, partly I know this because she has to try and interpret my gibberish. There's a part of it, and having been able to lean on valuable partners in the industry such as Sophie for guidance, I think. Give them another round of applause. Although, actually, I might just hold up, before we go to the panel, just in case there are any specific questions. Now you've walked off, I might make the privacy guys come back. I don't, maybe it must be a better brand. Here we are, we do have one. Do you mind shouting? Sorry.
Yeah, sure.
Excellent.
I was wondering if you're also looking at CDR, and because I understand that's going to move just from retail banking to other industries, if that's on your radar, and if so, what are you specifically thinking about in that area?
Yeah, on the radar, I think it's, they have said that, you know, it might, oh, yeah. Definitely on the radar. The previous government in particular was pretty keen to sort of translate it from the existing, I think, financial services industry only at this point, and into other sectors, including communications, telecommunications, etc. I need to have more of a think about what we can, you know, what our position is and as an industry there, but on the radar, and we will sort of see where it goes with this government.
Yeah, that was obviously also just picking up on what Sarah's saying, something that was picked up in the AdTech inquiry, sort of, and considered. And I thought what was interesting there is that there were really mixed views about whether or not it would translate well into sort of an AdTech environment. And I think they'll be the things that will be carefully scrutinised. Obviously, because obviously the entitlement, for anyone who's not familiar with it, the consumer data right essentially provides consumers with ability to take their data to a new provider. So if they were moving from one SVOD platform to another SVOD platform, potentially in the media context, they could be moving the data relating to their use of that platform when they go. There are complexities, including concerns about whether or not people would give essentially want their data ported, and how useful it would be to deal with the competition issues, which were the focus of that particular inquiry. So I think it's a bit up in the air about whether or not it's going to be extended.
Yeah, it's been a hot topic, I know, in Europe, data portability. Chris?
Sophie, when do you think people should have started thinking about this?
I think people have been thinking about this for quite a long time. So I think when GDPR came in, that was a bit of a wake-up call to a lot of people. But I think the rubber is really hitting the road. And it may feel like a long time, a couple of years, but it's going to go like that. And particularly if you look at people's technology refresh cycles, like typically people will be refreshing their technology every 6 years or so. Actually, depending on where your technology refresh cycle is, it could be quite urgent, because we've seen in the past, with previous law reforms cycles, that people's technology challenges can be quite significant. So I was just saying, essentially, that because of the planning that can be involved in just simple things like if you have complex software systems and you need to be capturing consents in a different way and causing systems to react differently to different pieces of data, there's actually quite a lot of work in that. So it's a time where I think it's very important for marketing teams to also be talking to their IT teams about implementation and the life cycle of your IT and your software systems, because actually, even if this law doesn't come, these changes don't come in for say it's 2 years and then there's a 2-year transition period, if you've got a 6-year technology refresh cycle, it could be right now that you need to really be putting those things in place. And that's why I think future-proofing data and systems is really important, and that contingency planning.
Yep, a lot of changes to come, and with it, challenges and opportunities as ever. Thank you so much, both of you, Sophie and Sarah. Thank you very much.